All right, welcome to week 13. We are almost done. We have probably another week of material left, and then we are in the final stretch. So, this week we're going to talk about transitional justice, and this whole module is around international law and kind of how we treat human rights violations. So, this week fully focuses on transitional justice and kind of talks a little bit about what justice is and what's the purpose of justice and kind of how do we define justice. As always, I will inquire or implore you to take notes as we go through this. I will post the PowerPoint so that you will have it, but make sure you read chapter 10 and let's go ahead and get started. So, what is transitional justice? Well, transitional justice refers to how societies respond to the legacies of massive and serious human rights violations. It asks some of the most difficult questions in law, politics, and social sciences and grapples with innumerable dilemmas. Above all, transitional justice places the spotlight on the victims. It recognizes that national and regional justice systems do not always protect human rights, but it always needs to focus on the victims and their dignities. There's some major areas of growth in international activity around transitional justice, and that's typically influenced by the UN's growth and the authority recognition that more countries are seeing. And of course, as we talked about last week, the Security Council has the authority to form international tribunals. And so it's one of the most powerful arms, of the United Nations. And so, in essence, transitional justice is the philosophical underpinning, questioning of who should be held accountable and how. There are three main goals of transitional justice. The first goal is to recognize the dignity of all people. So, as we've talked about human rights, we recognize that human rights are the minimal set of standards that people can live with to live dignified lives. And so, of course, the number one goal of transitional justice is to recognize that dignity of all people. It also has a goal to redress and acknowledge human rights violations, so bringing those violations to the forefront and to prevent them from happening again. Those are the three main goals of transitional justice. However, scholars have kind of added to some of these goals. So, as in, make sure that you can recognize the three main goals, but I'm going to add a couple of others. So, transitional justice also has a goal to establish a respect for the rule of law. So, essentially, transitional justice seeks to solidify the understanding that law is important to help us interact with one another. It also has a goal to make access to justice a reality for the most vulnerable groups, to foster durable resolutions, and to address the underlying causes of conflict and marginalization. So, in criminal justice, there's an ongoing debate around what is justice and how do we ensure justice is served? Well, um, transitional justice is human rights justice. And it's connected to human rights in a couple of ways. So it deals explicitly with human rights violations. Transitional justice deals explicitly with human rights violations, especially atrocity crimes that we talked about. It's important for ending those cycles of impunity. So remember when we talked about like the LGBTQ plus human rights violations, oftentimes perpetrators had impunity to perpetrate because of the societal norm and recognition of the outgroup. Well, transitional justice essentially tells us we need to end those cycles of impunity. And transitional justice really kind of what's the best word to describe it? Transitional justice really kind of puts out there this principle of universality. So remember, one of the principles of human rights is the universality of human rights, the equality of human rights. And transitional justice essentially puts that universality into the spotlight to say, absolutely, these are important concepts. Justice has to be sought for these violations. Now, it's not all sunshine and roses. There are a couple of concerns that kind of arise when we talk about transitional justice. So, the first one is victorious parties make decisions about post conflict justice. Go back to the Nuremberg trials. Essentially, the Allies were the ones that made the decision of how the Nazi Party was treated, and they defined what justice is. So, one of the ongoing concerns about transitional justice is the victorious party is the one who dictates what justice is. Perpetrators of crimes will be given amnesty during negotiations. We see that all the time. We see amnesty, we see um, plea deals, all of that um, given to perpetrators in order to maybe get to a higher perpetrator. And so throughout the criminal justice system, we have those concerns when it comes to plea deals. But essentially, with human rights, when you're talking about justice for human rights violations, you really see that some of these perpetrators may not all get what we determine as justice because we need them to give us information, and in turn, they're given immunity. And then the last kind of concern, major concern, is the legal system may have been compromised in the conflict. And so we've seen that state actors typically kind of dictate how human rights violations are addressed in their state. And so, in essence, this argument states that sometimes those legal actors were compromised during the conflict. And so that can sway on how they perceive justice and whether justice is truly given or not. If you take nothing out of this presentation, please take this. States are obligated to protect human rights. And remember, we're talking about this in an international sense. So states are not like the United States. It's essentially the countries. Countries are obligated to protect human rights. And so states who sign international treaties have the primary responsibility for ensuring the rights and freedoms within those treaties are protected. So remember, the United Nations can put out different treaties and kind of bring all the parties to the table, but those parties have to agree to protect the rights. And essentially, transitional justice states that if you sign those treaties saying that you're going to protect those rights, then you need to protect those rights. Um, Enforcement at the regional and international levels are still criticized. It really is looking at a micro level issue. And so it's still transitional justice is still saying it is the localities and the state's responsibilities. Yes, we have the responsibility to protect that R2P that we've talked about, that kind of we'll talk about here in a minute. But first and foremost, the international community only steps in when the states refuses to protect those rights or cannot protect those rights. So let's talk about the R2P, or responsibility to protect. Remember, state sovereignty was a huge deal with the Treaty of Westphalia. Was around for a long time, and then R2P became the international norm. And so R2P, or responsibility to protect, is the international norm aimed at preventing international atrocity crimes. It emerged in response to Rwanda and Yugoslavia, and there are three major stipulations to the responsibility to protect. So, first and foremost, states are obligated to protect their citizens from mass atrocity crimes. Again, it's the state's responsibilities. If they have signed onto these treaties to protect their citizenry, it is their responsibility to protect their citizenry. The international community will only be an assisting role. They will not take the primary responsibility. They will assist the states in helping them do it. However, if the state fails to protect their citizens, then the international community is obliged to help. That's when the obligation sets in, is when the state fails to protect or refuses to protect. Should be review for a lot of you, because we've taught in depth about the responsibility to protect. However, transitional justice really is rooted in this responsibility to protect notion, um, because it recognizes that the states need to recognize human rights violations. So let's talk about universal jurisdiction of the International Court. So we talked about the International Court. So certain crimes fall under the category of universal crimes. Those crimes are your atrocity crimes, genocide, war crimes, ethnic cleansing. All of that kind of falls into the category of universal crimes. Now, universal crimes are subject to what we call universal jurisdiction. This is a criminal justice class, so if you have not had any other criminal justice classes, jurisdiction is the approval of a court to hear a case. And jurisdiction can be limited by place of where crime happened. It can be limited by, like, federal crimes shouldn't be heard in state crimes because federal judiciary has jurisdiction or the right to hear those crimes over others. And so essentially, these universal crimes open up something known as universal jurisdiction, which means that the perpetrators may be tried anywhere in the world, irrespective of their nationality or of the state where the crime was occurred, was committed. And so universal jurisdiction basically opens up the jurisdiction to worldwide, because these crimes are so heinous that they fall under universal declaration. Within the broader category of transitional justice, there are three separate paradigms that we're going to talk about. And these paradigms are the philosophical underpinnings of justice itself. First is retributive justice. Sorry, that's a hard word. The second one is restorative justice. And the third one is reparative justice. And so let's take a deeper look at each one of these to kind of help you understand the philosophical paradigms of transitional justice. So, the first one that we're going to talk about is retributive justice. And retributive justice is all about retribution. And so that's how I always remember retributive justice. It's about getting even for a crime that has been committed. And so it involves the indictment, trial, and punishment of the perpetrators of the crime. Retributive justice is all about the punishment. So this conversation is no different than conversations we would have in a typical criminal justice class, because the criminal justice system itself for years has been under the retributive paradigm. And so when we think of criminal justice, we think of punishment. And so retributive justice, you typically see um, these trials being carried out by national courts or international tribunals. And a tribunal is a quasi judicial body that is formed for a particular case or crime. So you will see, you will have read more about that. But there are several different videos that I want you to watch, and I have these linked in Folio. Also, I'm going to upload this PowerPoint, and you can just click on the links, and it should take you to the YouTube videos. So remember, retributive justice was all about punishment. Now let's go to restorative justice. And restorative justice emphasizes restoring the relationship between the victim, the perpetrator, and the community. It seeks to dignify and empower victims. And generally, we see restorative justice, um, the restorative justice paradigm, embedded in what are called truth commissions. And truth commissions can be implemented and run by the national government. They're non judicial inquiries to determine facts, root causes, and societal consequences of human rights violations. They provide acknowledgement and recognition of suffering, and they typically will give some type of recommendation to kind of help in the prevention of these crimes happening again. There are four main benefits to truth commissions. So the first one is they have a broader focus than trials. They can focus on widespread abuses perpetrated by any number of individuals and on just the victims themselves. They can have an educative component through the broadcasting of public hearings and testimonies. And truth commissions typically disseminate a final report in which they kind of outline everything. These are not one size fits all. They can be tailored to the needs of the state and of the national government. So the national government is the one who kind of implements these and calls for these, and so they're the ones that kind of form the form of truth commissions. And then finally, they're less costly. So they're not full trials. So you're not paying for the trial. You're really just kind of paying for the investigators to kind of do all of this. It's important to note that there have been over 30 truth commissions established since 1974. 30 truth commissions established since 1974. Truth commissions are pretty common, and they primarily have been in Africa and Latin America. So now we're going to talk about reparative justice, or reparative justice. I'll call it reparative justice for right now. You may have heard of the notion of reparations. I know during the Black Lives Matter movement and certain social movements recently, there's been a lot of talk about re- reparations. Sorry, that's a hard word. Reparations are um, essentially um, kind of payments to make up for historical victimization. So it focuses on repairing suffering and loss. And what I want you to kind of think about, if you are repaying for the victimization, it doesn't necessarily mean money. So, what do you think is the most basic reparation someone can receive? Reparations begin with an apology. That is the most basic form of reparation that you can have, an apology. Now, it might not be the most fulfilling, but it's the most basic form. Then you kind of get into the monetary and compensation for past grievances, restitution. We see a lot in the criminal justice system um, with reparations. And so reparative justice, excuse me, reparative justice is all about repaying or repairing the suffering and loss generationally. All right, so we are at our last slide, and so kind of just wanted to do a review of what does transitional justice look like? Well, criminal prosecutions for the most for those responsible for atrocities. So remember, transitional justice looks at primarily atrocity crimes. And really, those atrocity crimes fall under universal jurisdiction, which means that they can be tried anywhere. Transitional justice really is a truth seeking um, endeavor. So it's more concerned with fact finding, not necessarily judicial um, justice, unless you take a retributive stance and you or the paradigm is a retributive paradigm. Transitional justice brings into the fold three different paradigms. So you have retributive, but then you also have restorative and reparative. Transitional justice really focus on the restorative and the reparative paradigms of justice. It looks for reparations for violations. It can be individual, collective, it can be materialistic or symbolic. So remember, the most basic form of reparation is an apology. And with restorative justice paradigms, transitional justice is really looking at highlighting the victim and recognizing the dignity of the victim because essentially the atrocity crimes committed against these victims sought to dehumanize and de-dignify and undignify them. And finally, transitional justice is reform of laws and institutions. We have to have movements around transitional justice, especially bringing in restorative justice and reparative justice, um, and let people recognize there's more than just um, retribution. There's more than just punishment. Really, the criminal justice system and the international system with transitional justice should focus on restoring the victim's dignity. And that starts with those institutions, and the state has to step up and be held responsible for the treaties that they sign and enforcing the treaties that they sign. All right, everyone. That concludes the lecture on transitional justice. Make sure you do the reading. And next week, we will wrap up with our final segment of this class and look at specific human rights violations in the criminal justice system. So I hope you all have a great week. If you need anything, feel free to reach out. Otherwise, I will see you next week.